I answered this question for Ed, and then I got to thinking about it, and I think I didn't actually answer the question for Ed. Or maybe I did. I don't know. Ed thumbed it up, so or somebody thumbed it up. But I was thinking about it, and I think this deserves a little bit more discussion. So Ed said, "We always hear when a person claims that she didn't know about the law or thought the law was excellent or really was why ignorance is no excuse. This doesn't apply to police officers when they screw up. It does. It does. If they break the law, then they are just as culpable as a normal person, unless the thin blue line protects them, which it absolutely should not. So yeah, if a police officer breaks a law, whether or not the police officer knew that there was a law to be broken or whether he misunderstood the law or not, it doesn't matter. He's culpable. And I don't know of any situation where you actually have to intend to break the law to break the law. You know what I mean? You don't have to be like, okay, I know that it's illegal to do X, and therefore I'm going to intend to do that or something. There's no time when a person can be excused because you don't know what the law is or you have a misunderstanding of what the law actually is. But what I think he was keying on, or I don't mean to misgender. So I think what Ed was actually going on was I stated in here that the police, if they make a reasonable mistake about probable cause, then it's good. And there's a lot of reasons why I say it. First of all, this is 148A. This is just a random jury instruction. You could see in it that there is no requirement that the person intends to break the law. It says, in fact, it expressly says that it's not required that he or she intended to break the law, hurt someone else, or gain any advantage. All they have to do for 148A is prove that a peace officer was lawfully attempting to perform his or her duty, that the defendant willfully resisted, obstructed, or delayed that peace officer in the performance of his or her duty, and that when the defendant acted, he or she knew or reasonably should have known that it was a police officer performing or attempting to perform his or her duty. So, for example, if you go limp, if a person intentionally goes limp, then that could be, if the other two elements are met, then that's resisting arrest. Whether you knew or didn't know that that would be resisting arrest, it is. So you don't have to know what the law is. You just have to intend to do the actions that are in violation of the law. If you intended to go limp, that ended up obstructing, delaying, or resisting arrest, then you violated the law. Knowledge of the law or lack of knowledge of the law is no excuse. But what I think he was going for was the reasonable mistake. The Fourth Amendment, the right of a person to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So the reasonableness standard stems from the actual text of the Fourth Amendment. Brinegar v. U.S. This is a 1949 Supreme Court decision. They define probable cause. The substance of all the definitions of probable cause is a reasonable ground for belief of guilt. And this means less than evidence which would justify condemnation or conviction. So it's a lower standard than beyond a reasonable doubt. It has come to mean more than bare suspicion. Probable cause exists where the facts and circumstances within the officer's knowledge and of which they had reasonably trustworthy information are sufficient in and of themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. These long prevailing standards seek to safeguard citizens from rash and unreasonable interferences with privacy, from unfounded charges of crime, etc. So that's the probable cause standard. Now in U.S. v. Leon, they extended it out to if a magistrate makes a mistake in issuing a warrant and the officers reasonably rely on it, then it's not a Fourth Amendment violation. If the magistrate puts the wrong address on the warrant and the officers go out to serve the warrant and they break into the wrong house and they shoot the wrong dog and they find the wrong drugs, then we're real sorry and everything, but that is admissible and it's not a Fourth Amendment violation. And then in Herring v. U.S., This one is from 2009. They extended it even further. So in this case, the officers mistakenly but reasonably thought that there was a warrant out on this dude. They pull him over. They find meth and a gun, I think. But the ultimate holding of it was that petitioners claim that police negligence automatically triggers suppression can't be squared with the principles underlying the exclusionary rule, as they've been explained in our cases. In light of our repeated holdings that the deterrent effect of suppression must be substantial and outweigh any harm to justice system, we conclude that when police mistakes are the result of negligence, such as described here, rather than systemic error or reckless disregard of constitutional requirements, any marginal deterrence does not pay its way. In such case, the criminal should not go free because the constable has blundered. So it's a reasonableness standard. If the police reasonably believe they have probable cause to arrest you, then that's all that's needed. And it's weird and kind of unfortunate. And California has put it in. This is 836 of the Penal Code. A police officer may arrest a person without a warrant, may arrest a person when any of the following circumstances occur. Part 3 is the officer has probable cause to believe the person to be arrested has committed a felony, whether or not a felony in fact has been committed. So they build in that officers are going to make mistakes. In fact, in Brinagar, it says room must be allowed for mistakes on their part. So that may be dicta, I don't know, but I haven't seen a state where they don't allow for mistakes on the part of officers, reasonable mistakes on the part of officers in determining what is or isn't probable cause. So I hope that helps. I know it sucks, but that's the current state of the law. Thanks again for participating, for giving me the comment, and have a great day.